In today's video, I'm going to discuss the top 10 things you should consider before you start your lawsuit in small claims court, coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. I'm Jordan Farkas, great to have you. And in today's video, I'm going to discuss the top 10 things that you should consider before you start your lawsuit. Okay, so a lot of you out there, I get it, you're frustrated, you're angry, you want to get your money back, you want justice, you want to win, and that's great. And your only recourse really is to go to small claims court, assuming that this is a claim that falls within that jurisdiction. And if you're coming to this channel, then I'm assuming that's the case. So your only recourse is to get to small claims court. But there's a lot of considerations that a lot of people don't think about before they actually even get to the batter's box, so to speak, before they even start their lawsuit. So I thought I would do a video just detailing what you may want to consider before you start your lawsuit. Get down to a list of 10. If you really think about it, you could probably come up with a whole lot more than this, but this should give you a good idea of the types of things that you should be considering before you start any lawsuit. So let's just jump into my list. It's not necessarily in order. I tried to have it go in some sort of reasonable, logical sequence, but these are not necessarily in order. The number one consideration that anybody suing in small claims court should take is the statute of limitations. What do I mean by the statute of limitations? Well, in most courts around the world, I would say, now obviously my audience is global and every small claims court will be different in every jurisdiction. It's hard to do one size all types of videos, but generally speaking, in most courts, in most court systems around the world, there will be a specific time period that you have to start your lawsuit before the time runs out. That's usually known as a statute of limitations. So for example, let's say you had a contract with somebody and he was supposed to pay you on, December 1st, 2023, for example. I'm recording this video in October 2024, but let's say somebody had to pay you by December 1st, 2023, December 1st passes and you did not get paid. So under most laws, there's a time period, usually from that date, from that trigger period. It really depends on the jurisdiction. I'm going to quote a lot in my videos from Ontario law because that's where I'm from. I'm from Ontario, Canada. So I always use that as my fallback example. So in Ontario, Canada, for example, generally as of the date of this recording, it will go by the date that you discovered that you had the ability to sue this person. So when would that be? So arguably on December 2nd, right? Because if you were supposed to be paid on December 1st and you were not paid, then your limitation period, your statute of limitations would start from December 2nd, 2023, the day after the day that you were supposed to be paid. And in different jurisdictions, you'll have different time periods. So in some cases, you'll have 2 years. Some places you'll have 6 years. Some places will really depend on the fact scenario and the circumstances. But just know that generally speaking, there is a time period for which you have to sue. You can't just sit on something, for example, just to take a random example, maybe some courts allow for 10 years, I don't know, but just to use a random example, generally, you can't sit on something for 10 years and then wake up one day and decide that you're going to sue. And there's a lot of reasons for this. One big policy reason is because the courts don't want people just having this idea that something could be hanging over their heads where somebody may sue them one day. Everybody has the right to finality. Even people who arguably screwed somebody over in business and they haven't paid you, even they're entitled to some sort of sense in finality. And by the way, you see this idea of statute of limitations in different areas of law, not necessarily just civil law, not necessarily just small claims court, but generally speaking, there is this idea that you have a time period to sue. So before you start your lawsuit, you want to make sure that you're within that time period. Now that said, let's say you find that you've run afoul of that time period of that statute of limitations. So let's say your statute of limitations was 2 years from December 1st, 2023, and 2 years have passed. Now, does that mean that you shouldn't sue? So again, that really depends on the jurisdiction that you're in. So in Ontario, for example, a lot of times you can start that lawsuit and then it's up to the defendant, or sometimes the judge or deputy judge, as they're known in small claims court in Ontario, will get involved to maybe make the point, hey, you've run afoul of the limitation period. But in a lot of jurisdictions, unless the defendant, the person you're suing, raises that issue, you could continue with that claim because the onus of proving limitations, the onus of making that argument is on the defendant. If the defendant has not made that argument, then you can continue with your lawsuit. So just because you've missed a limitation period, a statute of limitations, doesn't always mean necessarily that you shouldn't start your lawsuit. But of course, you want to be aware of the time periods always. You want to be aware of that statute of limitations. Of course, life happens, things happen where you didn't realize, and now it's 2.5 years later and you want to start that lawsuit. So don't necessarily give up, but certainly you should be aiming for ensuring that you file your lawsuit before the statute of limitations runs out. There's so much I can talk about with statute of limitations. There's a lot of cases out there that talk about this idea of when your time period runs out, when's that trigger date, when do you start calculating the time from. But the point is to be aware that you don't just have this carte blanche generally in most courts to just do what you want and start your lawsuit whenever you want. Okay, so always know when your statute of limitations is. Now, the next thing I jotted down here is the idea of jurisdiction, because you have to know where it is that you have to sue. So there's different courts that have different jurisdictional territories within their court system. So depending on where you're watching this video of, you should be aware of what the jurisdiction is for your particular small claims court. A lot of times it will go by where the defendant resides or where the defendant carries business. In other places, it will be the option of the plaintiff, i.e. the person suing, that's you, for the purpose of you that's watching this video, that can make that decision. Oftentimes it will depend if you had a contract that spoke to the idea of whether or not there's a jurisdictional clause based on a dispute arising. So a lot of people will have contracts that say in the event of a dispute, again, I'm going to use Ontario as an example, the Ontario Small Claims Court is going to govern. That's going to be the jurisdiction. So you should definitely look in your, if you have a contract that states what the jurisdiction is, and if there's no such contract, then you should do a bit of diligence to understand where you should be suing. Now, in most cases, the small claims court websites will have those resources for you to be able to do that check, but just be aware that knowing the right jurisdiction is important. That's also relevant, by the way. Now I'm going a bit out of order of what I jotted down here, but also suing in the right jurisdiction can be very relevant for collecting, because as you may or may not know, filing a lawsuit and even getting judgment is only half the battle, as the saying goes. A lot of times, even when you get a judgment, if the defendant, after the judgment, in many jurisdictions known as the judgment debtor, the person who owes you money under judgment, if that defendant doesn't make payment, then you oftentimes can only have recourse in the jurisdiction where you sued that judgment debtor, where you sued that defendant. So it's very important to know what the right jurisdiction is. Okay, now in many other courts, it won't matter. As long as you have a judgment, you can collect it beyond the jurisdiction and the territory. Again, a full discussion of that is beyond the scope of this video, but the point is to be aware of what jurisdiction that you're required to sue the defendant under, and then ultimately, if that defendant, if you win against that defendant and he becomes a judgment debtor, to know where you can collect against that judgment debtor. And that reminds me of another point here. Once I'm going into the idea of jurisdiction and judgment debtors of collecting a debt, is to consider whether or not the defendant has any property. Okay, because a lot of times, as I said before, you can win in a lawsuit, but going to collect is another matter. Now, how do you know, right? So what are some telltale signs of whether or not you think this defendant will actually pay up a judgment? Well, if the defendant has a lot of judgments against him, that's a pretty good indication that you may have trouble collecting against him. If the defendant's gone bankrupt, in many cases, if the defendant is under bankruptcy protection, you cannot collect your judgment anyways. Of course, the defendant could always go bankrupt after your lawsuit, but before you collect, and that can preclude you from collecting. But if you can see that the defendant has a lot of bankruptcies against him, or if you can see that the defendant is bankrupt or has a lot of judgments against him, or another example would be if you see that the defendant has put all his assets in his spouse's name, then that may be a sign that it may not be so easy to collect from this defendant. Now, again, does that mean that you shouldn't sue the defendant because it seems like it's insurmountable of an ordeal to go and collect from the defendant? No, because as I've learned in my many years of experience as an attorney in small claims court, you never know if you can collect, you never know what's going to happen. And anyways, as I mentioned with the limitation period, you want to make sure you secure your right, if you so decide to sue, to make sure at least you have that judgment. Because in most places, in most jurisdictions, judgments are not statute bound. They're not limitation bound. There isn't that statute of limitations to collect on a judgment. Some jurisdictions there may be, but in most jurisdictions there aren't. So at least to secure that judgment, at least you know you have it. Maybe the defendant will become wealthier one day. Maybe the defendant will get out of bankruptcy and you can collect. But still, it's important to know going in whether or not the defendant has assets so that you can know that you should collect. Now, you may be asking me, well, how am I supposed to know that? It's a very good question. A lot of times it will be common knowledge. Other times there are various softwares that people can use. There's something called skip tracing where you can hire private investigation firms. It's not always necessarily so expensive. Obviously, you have to weigh the amount of your judgment, the amount that you want to sue for rather, versus the amount that you would be collecting on, to see if it's worth spending this money on a skip tracer or somebody who can do a search for you to see what sort of assets the defendant or proposed defendant has. But nevertheless, whatever research and diligence you can do beforehand, if possible, you should be doing that to make sure that this is a defendant that you feel like you have a decent chance at collecting. Again, bearing in mind that even if you feel like right now in this point in time, this isn't somebody that you feel you may necessarily collect, at least in the future, then you may want to secure that lawsuit so that you have that judgment in any event. But it is something definitely to bear in mind. Of course, I didn't jot this down, so maybe this is an 11th, arguably. Whenever I get going with talking, all sorts of ideas come into my head from my past experiences. But also, you should definitely consider if you have a small claims court lawsuit or not, right? So, you know, the different courts have different jurisdictional limits. In Ontario, as of the date of this recording, the limit, unless they've changed it without me checking it, I didn't check it right before this video, but the last I checked, the jurisdictional limit was $25,000. You couldn't sue for more than $25,000 in small claims court. So you have to check what the jurisdictional amount of limitation is in your jurisdiction. Is it $1,000? Is it $5,000? Bearing that in mind, you can still decide to sue in small claims court in most jurisdictions, even if the amount is more. The only difference is that you have to waive any excess amount. So I've had many clients over the years come to me and tell me that they have a $30,000 debt that's owed to them. Should they sue it in small claims court? And I tell them, look, you can sue in small claims court. It's cheaper for you. You don't have the heavy legal fees that you'll have in higher court, but just know the most you can collect is $25,000. So that may be the case in your jurisdiction, and that's something you should consider as well. Should I go to higher court and get lawyers involved, or should I keep it in small claims court? Many small claims court, by the way, do have lawyers, and I do always recommend getting legal advice if it's cost effective for you. But assuming that you're in a jurisdiction where there's no attorneys or people don't generally use lawyers for small claims court, then you have to make that decision based on the amount that's owing to you if you want to continue in small claims court, or if it's worth getting attorneys involved and going to higher court and claiming for the full amount of money that you're owed. So that's also a consideration that you should be making. And that will, again, depend on the jurisdiction that you're in, how much is owing, what it may cost you to sue, and what it may cost you to collect, etc. Now, back to my list over here, I also jotted down who is responsible, because it's not always so clear cut who's responsible in every situation, right? So certainly in cases where, you know, let's say to take a tort case, right? Tort would be most commonly associated with personal injury. So let's say, yeah, and again, in some small claims court jurisdictions, you cannot sue for personal injury. So you have to make sure that this is something you can sue for. I'm just using this as an example of naming the right party. So let's say the city knew there was a speed bump. Let's say the city knew there was a pothole on their road and they failed to fix it. Now, you may say, oh, that must mean that the city is responsible. Now, that may be the case, but there may be another party as well. There may be the person that, or company that the city actually had hired to repair that pothole and failed to do that. So you really have to make a decision who's responsible. You know, oftentimes you'll have a contract with somebody to pay you, and the reason the person doesn't pay is because the people that didn't deliver the goods to that person should have delivered it to the person who owes you the money and never did. Now, that doesn't mean it's necessarily your problem, but you may want to include that other party as well as a defendant. So again, every case will depend on its circumstances, but you definitely want to do the analysis as to who the responsible party is. Of course, a lot of times, maybe even most times, it will be pretty clear cut. If you had a contract with, you know, A and A didn't pay you, then you're going to go and sue A. But sometimes it's not so clear cut. The water could be muddied somewhat as to who the responsible party is, and you should make that consideration before you sue. And speaking of making the decision of who you should sue, once you've made that decision, you've got to make sure that you name that defendant properly. Again, it will depend on every court and every jurisdiction. I know in Ontario, they can be very strict sometimes. So let's say, for example, you wanted to sue, I don't want to state a specific large company. I don't want to get myself into any sort of exposure here, but let's say it's a very large company and they're known as ABC. Okay, any reference to an actual ABC company is just coincidental, but I got to work on my disclaimers for these videos. But in any case, let's say you want to sue ABC. Now, the legal name for ABC may be ABC Company Limited. So if you just go into court and sue ABC, even if you were to, first of all, ABC may not even come to the table because they haven't been named properly, and they may have legal counsel that tells them that, don't worry about it. But in a less extreme example, if you want to, let's say you get a judgment against ABC, you may not be able to collect because the actual name of the defendant should have been ABC Company Limited. So you want to make sure that you know the legal name. Again, you may be asking, well, how do I know that? Again, there's all sorts of software in Ontario, for example. There's something called a corporate profile report where you can get the proper name. Not always so clear cut, depending on the circumstances, what the actual legal entity is. If you have the ability to consult with a lawyer, you may want to do that. But the point is to consider these things before you start your lawsuit to make sure that you're naming the right, not only the right party, but also properly naming them. Of course, in some jurisdictions, the judges will help you along, or the courts will, aren't as strict, or even if you do get judgment and you realize later that the defendant actually is known as a different name, a lot of times you can simply amend the court documents. So it really depends on the jurisdiction that you're at, but the point is to think these things through. Now, another question to ask yourself is not only who has exposure from the defendant's point of view, from the person you're suing, do you have exposure? Oftentimes, we know there's something called a counterclaim, and you may sue somebody, and somebody may say, hey, not only do I not owe you money, or maybe I owe you partial money, but you owe me money back because I was going to pay you this, and you were supposed to deliver this. Okay, I didn't pay the full amount, but according to the contract, you were supposed to deliver this to me, etc., yada, yada, yada. So oftentimes you should know that if you sue another person, or if you sue, the defendant may go and sue you back. So it's not always so clear cut that you're the only one with a lawsuit here. And you have to really consider, do you have any sort of legal exposure here? And that can be important because that ties into another point I'm making here, which is that, do you have the heart for this? So knowing that you may get sued back, it's one thing to sue and be a potential victor in small claims court, but think about if you were to be the potential loser in the small claims court. If somebody sued you back, not only can you not win your claim maybe, and of course I like to think positive, and this channel is about winning, but as we know, anything can happen in court. And let's say you didn't win in court, then somebody sued you back, then somebody could walk away with a judgment against you. So do you have the heart for that sort of idea of knowing that you have legal exposure? So that's something else that I jotted down here to consider, which is, do you have any sort of legal exposure? And not only that, by the way, I know that I haven't really been itemizing the list for you. In the comments below, in the description below, I'm definitely going to itemize it for you to make it clear cut what these 10 things that you should consider are, but I hope you're getting the points anyways. And you know what, I'll try and do a summary at the end. By the way, if you're enjoying this video, please don't forget to like and subscribe to the channel, which will help you as well as a subscriber to get notifications on future videos that could help you, especially if you've got a potential or you're in the middle of a lawsuit in small claims court. But it also helps me, so I'd be very grateful. Now back to this program. So something else to consider, not just the legal exposure, is reprisals. So I can't tell you how many times I've had all sorts of neighborhood dispute clients, and even though the neighbors that they were filing a lawsuit against didn't have a legal claim against them, they went and, for example, complained to the municipality or to the city against them. And that led to all sorts of headaches for them that they wouldn't have otherwise wanted or anticipated, and far more than the actual amount that they were owed in the first place. By the way, in case you're wondering, these are discussions that I would have had with clients, and they either would have decided to go ahead and do it anyways, or maybe they came to me after this happened. So don't think that I don't discuss these things, or I didn't. Now I'm retired, but don't think that I didn't once upon a time have these discussions about reprisals with clients. All the things I'm talking about in these videos are things that I generally would have brought up with my clients, or things that came up from my years of practice. But the point is to always consider, will the person take a reprisal against you that can really damage either your peace of mind or your business or your personal life in any way? Of course, no defendant is happy being sued, and I'm not saying you should shy away or be scared from a lawsuit, but you have to know yourself. You have to know if you have that personality for it, if you're willing to put up with that reprisal, and what the potential reprisal that the person may take may be, even if it's not lawful. And something else that's tied into the idea of the debtor having assets is, can you locate the defendant? Okay, so obviously in order to serve the defendant in most jurisdictions, the onus, the burden is on you as the plaintiff to locate the defendant and serve that defendant. Serve means provide the defendant with a copy of the lawsuit, with a copy of the claim in which you're claiming that this defendant owes you money. And if the defendant has skipped town, for example, and that's another indication, by the way, of when I talked about before, does the debtor have assets? If the debtor doesn't even live anywhere near you anymore and move to another country, that may be another indication that this may not be the best defendant to sue. Not that they should get away with it. And again, you may want to secure your rights anyway, but if the defendant isn't even living in your country, then that's something to bear in mind. But not even taking such an extreme example, let's say the defendant is living in your country, but you don't know where the defendant is located. That may be something based on your jurisdiction where you have to find that defendant in order to serve him. So make sure that you consider if this is a type of defendant that you can locate. Again, you may ask, well, how can I know where the defendant is located? Once again, the same idea. You can get private investigation, something called skip tracing, all sorts of different ideas that will maybe be able to help you locate that defendant. There's process servers that can oftentimes help you depending on whether or not that's an add-on service that they will provide. But the point is to make sure that you think these things through, because many courts, if not most, don't locate defendants for you to provide them with a copy of the lawsuit. You have to locate them for yourself. And finally, one last thing I jotted down is before you rush to court, and again, bearing in mind statute of limitations, as I talked about from the get-go, do you want to start with a lawsuit? Maybe you can come to some sort of peaceful resolution. Obviously, if you have a mutual friend or something of that nature, that's always something worth exploring. Most people don't want to necessarily get involved in their friends' disputes. But let's just say it's a plain and simple, so to speak, business dispute. You're not friends with this person. You don't have mutual friends. It was a pure business deal that went bad. Then you may want to start with a collection letter before you run to small claims court. You may want to start with a letter of demand. Now, why do I say may? Why don't I say every time? Because surely if you could send a letter and get paid, that's great. Well, I say that because sometimes that letter can have the effect of tipping off the defendant, and maybe the defendant runs away, for example, or maybe the defendant goes and sues you first, so then positions you as the plaintiff, and then positions you as the defendant. And in court, sometimes it looks better to be the plaintiff as the one suing as opposed to the defendant, the one being sued. Even though you can do a counterclaim, still you've already been positioned as a defendant as opposed to really being a plaintiff, which is what you are. Again, I'm taking extreme examples, but it's not always advisable to go right away with the demand letter. But I would say in more cases than not, it's better to start with that collections letter as opposed to going straight to court, because again, the court can be the Wild West oftentimes and anything can happen. But obviously, if the collection letter does not work, then the next step, assuming there's no other issues that we talked about earlier that preclude you from suing, the next logical step would be to go to court. Now, how you word that letter, you can use an attorney, obviously, to word it. If you send it on your own, there's the idea that you catch more bees with honey, but then there's the idea of not being too soft. That's beyond the scope of this particular video. Maybe I'll talk about that in a future video, but just bear in mind that there is that idea of starting with a collection letter. So just to do a summary, I bet I went a bit out of order from my list, so forgive me if this is out of order in summarizing, but one thing you should consider, number one, is the statute of limitations. Number two is what is the correct jurisdiction. Number three is who is the responsible party. Number four is naming the defendant properly once you've decided who that responsible party is. Number five is, do you yourself have exposure? Number six is, what about reprisals, even if you don't have legal exposure? Number seven is, and this is going to become 11 because I'm remembering now, I talked about the idea, number seven, of suing for the right amount and knowing if this is something within the purview of the small claims court jurisdictional limit of how much you can sue for. Number eight is, does the defendant debtor have any assets that you can collect from? Number nine is it the right idea to start with court right away, or maybe you want to start with a collection letter or a letter of demand, a 7-day letter. It's got all sorts of different names. And finally, number 11, I guess, is, do you have, I kind of talked about this before, so it really does fall under the reprisals category. Do you have the heart for it? Will you have the peace of mind knowing that it could get pretty messy in court? Things could get, there could be reprisals, there could be all sorts of stress along the way, because nobody's suggesting that small claims court is always easy. Reminds me of the song from Coldplay, nobody said it was easy. And that's why I'm an attorney and not a musical artist. Hope you found that video helpful, and I look forward to seeing you at the next one. Hey, if you like that video and you feel it's going to help you win in small claims court, check out the next video I've got queued up for you. If you haven't already done so, I'd be very appreciative if you hit that subscribe button and the notifications. Definitely helps me, but it will help you not miss a future video to help you win in small claims court. Don't forget to hit that like button, and also feel free to leave a comment, and I'll see you at the next one.